Hi everyone, Attorney Rachel Gretzner here with another Family Law Friday. This week I'm answering the question of, should I block my spouse on my social media during our divorce? So the very first thing I can say about this, just generally, not even talking about blocking your spouse, is this. Do not use your social media as a platform to vent your feelings during your divorce. Do not use it to complain about your spouse. Do not use it to complain about their parenting. Do not use it. Now, obviously, a lot of the divorce process is processing through your feelings about your situation and about the changes to your situation that you're making. However, why would you want to put those in a platform where anyone, could see them and then potentially get that information back to your spouse or back to their attorney or back to, even worse, your children, right? And the reason I say that is because do you want the possibility that your own very raw thoughts and feelings are going to be in the hands of someone who may want to take those raw thoughts and feelings and turn them around and use them against you? Or do you want to just have a written journal and write down your own thoughts there and maybe call your therapist and read them to your therapist and work through them that way, as opposed to putting them out somewhere online? So that's just the first thing to think about. The other thing you need to think about is blocking your spouse on social media going to help you have a good relationship with them once that divorce is final? And honestly, I think that the answer to that question really just depends on the nature of the relationship you're able to have with your spouse after the divorce. So in some circumstances, for some people, it's just not possible for them and their ex-spouse to have a normal or even a tense relationship based on power imbalances or mental illness or potential other issues, right? And so for those people, perhaps blocking your spouse makes sense because it's the best way to really cut that tie and end that abusive relationship. But for other people, sometimes cutting that tie on social media can feel like a huge rejection to the other parent, that maybe you didn't need to make that additional rejection to them. I mean, you've already rejected them, right? Your relationship is already ending. So is it really necessary to go that extra step and say, I'm going to block you and I don't want you to have any insight into, my private life? And I will remind people that there's always an opportunity, particularly on Facebook and I'm sure on other forms of social media, that you can limit the audience of your posts. But I encourage people to think about these things, overwhelmingly so, because so many times social media posts that end up in my hands and that end up as potential evidence in cases didn't necessarily come directly from the opposing party, and my client still had access and so they were able to see it. But a lot of times it's what the opposing party is saying on social media that either was publicly available and so my assistant went and pulled it off the internet, or that a mutual friend is still friends with that ex and they got that information and sent it to our office or sent it to our client, who then sends it to our office. And so, it's really just a reminder that anything you put on social media, it's out there forever. It is not in any way, shape, or form ever confidential. And any statement that you make against your own interest can be admitted as evidence in a court of law against you, unless for some reason a court determines it's not relevant. And if you're on social media, cussing your spouse out up a storm and talking about what a terrible parent they are and how, sad it is, what a terrible parent they are, that evidence could very well end up in front of a judge. And many times, judges aren't going to take that evidence and say, oh, well, so-and-so said that their ex is a terrible parent, so their ex is probably a terrible parent. It's not how judges see that evidence. A lot of times judges see that evidence as, wow, so-and-so thinks X is a terrible parent, and instead of having a rational communication with them about, some parenting issue that they had, they went and blasted them on social media. And that certainly doesn't encourage a good co-parenting relationship. And, well, ding that, person who went on social media under factor J of the child custody factors. So overwhelmingly, it's just best not to vent those things on your social media. But the last thing you want to think about, though, if you're considering whether you're going to block your spouse, is, are you under court order not to? Or are you under court order not to destroy evidence in your case? So it is very rare for courts to issue an order that specifically says, do not delete anything from your social media, right? However, there is a general rule: when you are in litigation, you cannot destroy or conceal any potential evidence in your case. And so I will frequently advise my clients, listen, now is not the time to do the social media scrub. You can go ahead and take your social media profiles offline, but don't delete anything, because it may be that you later are under a court order to produce that information. And if you've deleted it, now it makes you look guilty. And maybe you don't have to look guilty. Maybe, you're just deleting normal things that don't have any consequence to your divorce, but ultimately that might not matter depending on how it comes out in your case. So it's really important that if you have a social media presence during your divorce, that you're being very critical about what you're posting, about who is going to see it, and about deleting any information. I hope that this tip has helped you. If you have any questions about filing a divorce, preparing for divorce, or how you should deal with internet interactions with your ex, give our office a call. We're here to help.